where you can basically track what someone's speed is and maybe attach tickets based on the reading of when they came on and when they came off. Was that ever discussed?
That's a great question. It was not. We just addressed that was the bill that was before us.
Okay, and so no one was aware that that technology existed?
Nope.
Okay, thanks.
Other discussion on the full bill? Okay, then we have a motion and a second. All those in favor of the bill as amended, please say aye or raise your hand.
Aye.
Anyone opposed? Okay, so it looks like Delegate Queen and Kaiser are opposed. Am I missing anyone else as I'm looking through the cameras? And Delegate Miraku North?
Yes, Madam Chair, I'm sorry, change my vote.
That's, well, you're not changing. I'm just trying, sorry, scrolling through the cameras here. So I think just those three folks. Okay. So Queen, Miraku North, and Kaiser in opposition on that one. Thank you, colleagues. That bill also passes out favorably. And thank you, Chair Love, for your committee report this morning. We will turn now to Chair Crutchfield for the bill reported out by the Education, Elections, and Housing Committee.
Great. Thank you, Madam Chair. And before I do that, I just want to make sure that for the record, on the third amendment that was posted or requested a vote on, that I am affirmative with that amendment. Sorry, something is going on with my...
Got it. Yeah, the internet is not great this morning in the office.
Yes, yes.
Okay,
and I'm in my office as well. So thank you. But anyway, all right. So the Education, Election, and Housing Committee had one bill to come out of committee. It was unanimous. It was MC 8-24, and that's dealing with restrictions on real property. There was an amendment to the bill as well. That bill basically voids and makes unenforceable in Montgomery County any restrictions that prohibit the use of real property for housing units. And so there was an amendment to the bill which clarifies what restrictions are, and it actually was incorporated into the bill, and it identifies restriction on use to include any covenants, restrictions, or conditions contained in a deed, a declaration, a contract, bylaws, security instrument, and any other instrument affecting the transfer of real property. And so that is the First Amendment and only amendment. Madam Speaker, I'll turn it back over. I'm sorry, Madam Chair, I'll turn it back over to you.
Yeah, and actually just a procedural question. I thought I saw an email last night from the council to your committee about that maybe that change was incorporated, was yellow sheeted into the bill. I don't know if anyone can speak to that, if any of the staff can speak to that.
That is, and I don't mean to jump in front of Ralph, but that was my understanding. There's a period of time prior to the bills really being considered by the delegation where the sponsor can request changes before it's kind of finalized. So that is my understanding of what happened here in terms of the process of this bill.
So just to clarify then, Jen, thank you for that information, or Ralph. So we don't need to vote on that as an amendment. That just is the underlying bill.
It's part of the bill now. Yeah. Yes.
Right.
Correct.
Okay. Perfect. So if we, Delegate Crutchfield, excuse me, Chair Crutchfield, if we could get a motion on the bill and a second, and then I see there's some hands up.
Okay. And so I move that a motion for the bill.
Second.
Okay, so moved favorable by Delegate Crutchfield, seconded by Delegate Kaufman, recognizing Delegate Foreman.
Thank you, Madam Chair. I do have some questions about this bill. Chair Crutchfield, I appreciate the explanation, but perhaps if the sponsor, if it's appropriate, could just kind of briefly explain what we're trying to do with this bill.
Sure, and Delegate Moon is welcome to respond.
Thank you, Madam Chair. Thank you. So just a point of clarity on the process for the bill. So when we went to the local delegation hearings and the bill was first posted on the county delegation website, the language was far more expansive than what you see as HB 1300. And so you heard why that happened process-wise, but there may have been some confusion about the bill as a result of that. So I apologize, but we did gain some clarity about how to craft this language after working with the Attorney General's office, taking a closer look at how DC is undertaking this effort District of Columbia, excuse me, and talking to additional stakeholders. So what the bill does is it seeks to invalidate decades-old housing restrictions on housing that were put in place by property owners and homeowners associations over the years, and to basically protect the careful modern zoning that the county has undertaken. And that's actually there's a time restriction that came in under the changes that I was just referencing. So if you look at the very bottom of the bill text, you'll see some uncodified language that says specifically this bill would invalidate HOA covenants and restrictions that came onto land before 1958, which is when Montgomery County adopted a comprehensive zoning code and would have made all this unnecessary. So the reason for it, the reason I'm taking a look at this and why Montgomery County has been looking at this, as well as the District of Columbia, I don't know if our chat is active, but if you go to the Googles and look for the term Montgomery County, Maryland mapping segregation, you will see that Park and Planning has attempted to chronicle this history of zoning restrictions. And these came in at a time when folks were putting in racial, ethnic, and other restrictions on who could live in a neighborhood, but they often also came in with language that said something like no black residents here and no apartments, or no black and nothing other than a single family home here. And so again, if you go to that Montgomery County Mapping Segregation Project, you can toggle through and see the single family covenants that came in over the years. You can see the racial and religious covenants that came in. And basically what these covenants do is they make it so that some landowner or neighborhood decades and decades and decades ago made a decision to restrict housing on that land for in perpetuity for generations to come, for all future users and owners of that property. And that is what this bill would seek to invalidate. It doesn't mean you lapse to and anything goes. It just means that the county's current zoning restrictions and scheme will take hold. Is that
Madam Chair,
basically?
can I ask some follow-up?
Yes.
Certainly.
Thank you. So, Leader Moon, first of all, you've used the term HOA a couple of times, and I've kind of learned a lot in my new position. That's a very specific type of neighborhood. So this actually applies to any pre-1958 neighborhood covenant, right? It's not actually
that is correct. The HOA is a common frame of reference, but it could, like in DC, actually, the covenants. I'll give you a specific example from DC where you have in Chevy Chase, they had a parcel where they were trying to develop affordable housing, and on a corner of it, they discovered that the Chevy Chase Land Co. owner had put a restriction on a piece of it, and so folks felt that was inappropriate, and so they are seeking to invalidate that.
Okay, I mean, I have no idea if that has an HOA or not. I'm just trying to make
No,
the point.
I don't think so. I think that was by the property. Yeah.
Yeah. Okay. Thank you. Also, I mean, racial and religious covenants are already unenforceable, right? So that this bill doesn't change any existing law on that. I mean, there's Supreme Court precedent that makes those unenforceable, right?
That is correct. And so I guess the reason to explain that is, these restrictions, so facially, they might be neutral, but I guess this part of mapping these in tandem has been to give people an understanding of the larger context in which some of these restrictions came into place.
Okay, and I just for my continuing education, local zoning doesn't already make these covenants unenforceable. The covenants on housing, not the covenants on race and religion, which are
correct. That is a very interesting question. And so I'll give you. So I'd say, I mean, if you'll look, the way the planning department, even in the way they mapped this, they said if you go to the again if you Google over to mapping segregation Montgomery County, you'll see a map, and you can choose various things, and they'll say single family covenants possibly active, and I think this is a question. And so part of what this bill would do is resolve that uncertainty. So here's how one example of this plays out. Montgomery County some time ago adopted basically a by right accessory apartment policy so that people could whatever put a carriage house or rent their basement if they met certain conditions. And a lot of these covenants might say something like single family only. That would certainly call that policy into question. Well, the county in its permitting already does not accept a covenant-based challenge to an accessory apartment application. But that's not going to stop necessarily someone from suing you to enforce it, otherwise running up cost on you or clouding the situation. I've asked folks from zoning issues past if this has come up in the county, and we've certainly had large parcels of land that had exchanged hands with people attempting to put housing there in past years, only to discover that there was, in fact, a covenant like this on there.
Sorry, I have two more questions, if that's okay, Madam Chair. The first is, a county could not adopt your bill themselves, right? It requires a change in state law.
I do believe that is correct.
Okay, and so my second question is, have the county executive and/or county council taken a position on your bill?
I have not seen anything from them. This bill's been circulating. I've been having my office make sure folks are aware of it. I've heard from planning, DHCD, the Attorney General's office. Not everybody is what, but people have looked at it, reviewed it. They're comfortable with the language. I do think the planning folks are supportive of this, but I've not heard from the county.
Okay. On the bill, Madam Chair?
Certainly.
So on the bill, I'm channeling my inner Kumar a little bit here, so I apologize, but this bill will come to the Environment and Transportation Committee, and I will vote to advance the bill today because that is how we scheduled the hearing, but this is going to require a lot more inquiry and discussion. Delegate Moon, because there is a lot of confusion about what this bill does and what it's aiming to do. And I appreciate you've spoken to me both offline and here to try to clarify it, but I think it requires a lot more clarity. So I will vote procedurally to advance the bill today, but I just want to be clear that it will have a full hearing at its next stage of the process.
Mr. Chair, this sounds ominous.
Like I said, my inner Kumar.
Thank you both. Recognizing Delegate Spiegel.
Thank you, Madam Chair, and thank you, Delegate Moon, for the work on this. I appreciate your comments in particular about the very troubling and atrocious history of redlining. Certainly something a number of us know about. I've worked on it in trying to educate folks at the municipal level, working together with then Mayor, now Council Member Kate Stewart, quite a bit on it. So I appreciate the intent, but I do have some technical concerns and will associate myself with the comments of Chair Corman. A couple of specific questions. First, I noticed that in the uncodified language at the end of the bill, yes, you've got this provision that talks about how it applies retroactively only to bylaws or rules of a condo or HOA prior to June 1st, 1958. But there's also a provision that says, except as provided in that part, it is applied prospectively. And there's also references to restrictions in deeds and declarations. So I'm just trying to understand, does that mean it does apply prospectively to future deeds and declarations as apart from HOA and condo bylaws and rules?
Delegate Moon.
Thank you, and I apologize. I only gave part of the explanation. You flagged correctly the fuller application of the bill. So again, going backwards in time, the intent of the bill was to find a reasonable marker in time where we hadn't gotten into fair housing laws and we hadn't gotten into modern comprehensive zoning in Montgomery County, and that's where we got the 1958 number. Again, I think in DC they went somewhere in the 20s or 30s, 1920s or 30s, in how they approached this based on the restrictions they saw there. The bill also has a prospective application. In other words, we're saying, all right, and as of the effective date going forward, we would like to not replicate this problem in perpetuity in the future. And so, in other words, if you live in Montgomery County, going forward, we live in a place with modern, professional, comprehensive planning and zoning. And that is what ought to stand. We really ought not have neighborhoods or property owners trying to band together to opt themselves out of the county's comprehensive zoning and creating a lack of clarity about housing production. So that is in fact correct to flag that there's a prospective application.
And is that prospective application to all categories listed in the bill or only for deeds and declarations? In other words, does it also prospectively apply to condo and HOA bylaws and rules going forward?
That would be correct. I mean, certainly the condo or HOA could enact such a bylaw. As to whether someone could use it to attempt to usurp county zoning, that it would clarify that situation.
Okay. And Madam Chair, if I may, one final question. I understand that the intent is that the restriction on use is really designed to target the type of residential unit we're talking about. But as written, does the bill also apply in general to potentially other restrictions on use? I'm thinking, for example, a hypothetical where a homeowner could not be prevented under this bill, if it passed, from redeveloping their single family home into a duplex or a triplex. But there are other rules and regulations that we find in declarations and in HOA bylaws regarding design guidelines, for example. What does that duplex or triplex have to look like? What color does the roof have to be? What type of shingles does it have to use? Those kinds of things. Do you envision that the bill as drafted would impact an HOA's authority, for example, to impose regulations on design guidelines of a building as opposed to the type of residential unit it is?
No, and in fact, in the deletions that happened between the bill that was posted on the county delegation website and what you see today, many of those deletions were asked to things like in previous drafts, it says actually we were looking at things like height, setback, and we took all of that out and tried to strip this down into a restriction that prohibits the use of property for housing units that are allowed under law. And again, this is the core of the bill. The county says Ryan Spiegel may use this property for this type of housing, and the deed says he cannot. In that specific housing unit conflict, the county zoning would prevail, and that is all. And again, we've trapped this exact question back by the planning folks, DHCD, and the Attorney General to try and get clarity on whether we had properly stopped some of those collateral applications. If we've got it wrong, then I'll lean back on Mr. Chair channeling his inner Kumar that I suppose that will be the place where we will hopefully get an initial additional vetting. And look, this is a bill of first impression. It was brought to me by folks who were monitoring some of the developments in Washington, D.C. And so I thought it was important to bring here. I'm certainly not going to claim I've nailed it 100% on my first go around on the language. So I'm open to nips, tucks, and tweaks as needed to steer the language to its intent if you think I haven't got it right.
Thank you very much, Delegate. Thank you, Madam Chair.
Thank you both. Any other questions? Not seeing any. We have already moved and seconded, let's see, MC 8-24. So if folks want to come back on camera, we're going to vote. All those in favor of the bill, please say aye or raise your hand.
Aye.
I think we have some lagging internet, or maybe it's just me. We'll give it a moment.
Aye.
Okay, is anyone opposed to the bill? Don't see any hands, and I just want to say for the record, both Delegate Chetty and Delegate Solomon were voting on camera, and that phone was being operated by a passenger in a vehicle, not by a driver. Okay, so that bill passes favorably. I believe that is all of our bills for today. I do just want to make a note. Delegate Acebaro is excused today from our voting. Let's see. Do any committee chairs have any announcements about upcoming meetings? I realize we're emptying out our drawers here. I think we have 2 bills left on our side, and then still the potential for some bi-county bills to come over from Prince George's County that are not yet in our hands, but any announcements? Okay, not seeing any. Just lastly, just for the record, for posterity's sake, did get a notification that our live stream, I guess, had cut out at a couple of points, and just so everything is on the record, today we did vote out favorably MC 824, MC 1124 with 3 amendments, and MC 1224 with 1 amendment. I think with that, that is everything for today. So we will adjourn our meeting. Thank you all.